We're mostly interested in trying to figure out patenting, the process and what in which to take. We're still in the, like you said, the preliminary research.
Right.
So we're trying to figure that portion out, make sure that we can patent the product that we're looking to do so.
Okay.
And then, of course, go from there.
Right.
Is that smart to do, or?
Yeah, patenting is always a good idea if you've got a patentable invention. So I can back up a little bit and talk about patentable subject matter. It includes basically any invention, like an iPad. That is an iPad, right?
Yep.
Just a little guy. An iPad, air conditioner. The automobile was patentable at one point. So it covers articles of manufacture, compositions of matter, methods, and anything. For the most part, it has to be tangible. In some cases, there's software that can be patentable and computer methods that can be patentable, but usually it's tangible materials.
I'm sorry, not to cut you off. What about ingredients?
So that would fall under composition of matter unless it gets a little bit confusing. Something along the lines of Rich Products non-dairy creamer is patentable, but a recipe for chocolate chip cookies would not be patentable.
Right.
So if you can figure out which one it falls into without disclosing it, then
Sure.
then that would be good.
The process in which we should take in different outlets. Maybe we don't have to get a patent. Maybe it's some other gateway or segue that we can use to try and protect the product.
The only other thing that you could use would be trade secret.
Okay.
WD-40 is a great example of something that's covered by trade secret. So the composition, nobody really knows what the composition is, and they've been using it for years, and they've been protected that way. The recipe for Coca-Cola is another trade secret, and then also the recipe for the secret sauce for Kentucky Fried Chicken. So I don't know how it works. I think they've got different people working in the factory, and they know two ingredients, but they don't ever get together.
That's a good point. I always wondered that.
Right.
Yeah. Like someone's got to know it.
Yeah. So the downside, so a trade secret, that it doesn't cost anything. It lasts as long as it's a secret. The downside is if somebody figures out what you've done, or if it somehow becomes not a secret, then there's really not much you can do. There are some lawsuits you might be able to file depending, but if somebody just reverse engineers what you've made, then then you're sort of out in the cold.
You want to say SOL and stuff.
Yeah.
So the best bet will to go through and try and patent.
Right. Usually, the patent protection does buys you a lot of protection, and it keeps the reasonably prudent business person away from stealing your idea, or your invention rather. In terms of the process, there are two different types of patent applications that can be filed. There's a provisional patent application and a non-provisional patent application. The non-provisional is easy because that's where you're actually asking the government for a grant of intellectual property. You've got all the information in there that you need, and everything is covered. The provisional can be done before the non-provisional, and what that does is it's sort of a placeholder. It buys you 1 year to file the non-provisional patent application, which is the regular patent application. The provisional is a little bit cheaper, it's a little bit quicker, it doesn't have all the legal requirements that the non-provisional has, and you get it on file. Within a year you have to file the non-provisional. It's never examined at the patent office, it just sits there holding a place. The upside is that it gets you a filing date. So you can, if you've got your composition of matter, you can go out and sell it, you can test the market, you can advertise it as patent pending and see if there's interest out there. So Ideally, you file the provisional patent application, you go out there, everybody's super interested in it, you make a lot of money, and then that helps you pay for the non-provisional patent application. The other case is you file the provisional patent application, you market it, nobody's interested, they tell you it's terrible, they hate it, and then you spend a little bit of money, but not as much. And then the worst case is if it's somewhere in the middle, where there's some interest, but not as much as you had hoped, and then you've got to make the decision. You see that a lot too, because a year is not a very long time.
Right.
So, and then the other thing is, the non-provisional can't just be filed in one day, so we need a couple months to put it together. So the 1 year is not truly a year. It's maybe 8 to 9 months.
Okay.
So,
Which is
and it goes by so fast.